Like to bring this meeting to order. Welcome to the February 2025 City of York Zoning Hearing Board meeting. You were before the Planning Commission already, and that has now brought you before us. We do take their recommendations into consideration, but we vote on our own decisions. Please silence your cell phones at this time. We ask that when you come to the mic that you make sure you speak into the mic so that our stenographer can hear what you're saying. We ask that everyone speaks one at a time so she will be able to capture everything that needs to be notated. Anyone who plans on testifying or speaking tonight, I ask that you please stand so you can be sworn in. Raise your dominant hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you? And if so, please respond, I do. Let the record notate that everyone who is present at this time has been sworn in. I'd like to introduce our board to you. To my right, and would be your left, is Blade Klein, Adam Nugent, Franklin Williams, Nick Holman, my vice chair, and I'm Sina Jenkins. And to my left, our solicitor tonight is Tom Lang, and our stenographer is Karen Brown. Okay. Solicitor, will you please swear in our first case?
Yes, Mr. Chairman. The first case is 525-Z-SE-V. The applicant's Dean List Realty LLC, 289 Kings Mill Road, York, PA 17401. The owner of the subject property is also Dean's List Realty. Subject property is located at 1237 to 1239 Roosevelt Avenue, which address is located in the EC Employment Center District of the City of York. The applicant seeks 4 variances. The first variance is to expand a non-existing or to expand an existing nonconformity, The second is a dimensional variance for the new proposed parking lot. The third is a variance for rear setbacks from an existing nonconformity, and the fourth is a variance for side setbacks, another existing nonconformity. After review, the planning staff recommended denial of all variances. The Planning Commission heard this matter on February 10th, 2025, and approved unanimously all variances. The record before the board this evening consists of the application itself, a narrative of the project, a zoning determination letter from Officer McMillian, the deed of the subject property, an aerial view of the subject property, a plan of the proposed project, and photos of the proposed project location. Mr. Chairman.
Thank you. Okay. And if you will please state your name with the spelling.
Ross Dean, R-A-S-D-E-A-N.
Okay. I ask that you take this time and go ahead and present what you have for us.
I am seeking for permission. I set out about almost 3 years now trying to renovate the property that I bought at 1237, 1239. At the time, we had blueprints done, engineering came in, did some engineering work, and then a survey as well. We submitted the stuff to the city, but even though the building is existing, it doesn't meet the current zoning requirements for the setbacks, what have you, and parking. So we had multiple meetings, a couple years now, and then brought us to finally getting to this stage where to go to the Planning Commission and the Zoning Commission. We asked for approval to keep the project moving forward. The plans haven't been reviewed by the zoning department yet, which also takes about a year or two just to review the plans, but this is the step we have to take just to get the plans reviewed in order to move to the stage.
are we going to see if the applicant would like to proceed with as much as we can?
Well, so there's been an issue that's been brought before the board, and that's what they're talking about up here, in that there's a property line issue where some of the relief you're seeking is across a property line that the board is not sure that you own. And since it was applied for with that included, the concern is whether or not you can get the relief you want. And so what I was discussing with the board, and unless you can explain it, and I frankly, I haven't looked at the property line issue myself yet. It's just what I've been told by the board. I'm going to look at it right now, but are you aware of a property line that where
Yes.
do you own both those properties, or can you explain that?
Correct. So I had a survey done. My attorney was Mr. Peter Roof, stock and leader, who did the title work and went back multiple deeds to actually give me this property or sell this property. So they was part of the sale was along with Rock. A couple years later, the neighboring property did say, or just came forward maybe the last meeting and said that the deeds aren't correct. She told me that she thought her property was on the magistrate, but the magistrate told her no, her property line has to move over because they own the parking on her property and not her. So that has to be resolved. But at the last meeting, it was something that me and the owners would have to resolve because both of our deeds are probably incorrect at this time because mine is correct and theirs is correct. So somebody is wrong, so it's not something that they did because it was prior, what the attorney said, it was prior to the owner and it was prior to the owners that sold it to me and how they, at the time, even created this property wasn't done correctly. So never before one property is built on 2 or 3 lots. It's because if somebody sells one lot, then you have a property that you have to split in half. So unless the property was torn down, it wouldn't happen. So what they told me is the best way moving forward is to the line is for the current parking that we have. So our current parking, you have to drive in the driveway and pull into the parking spaces. So the neighboring property said that that driveway is actually theirs and it's not a right-of-way, that's on our property. So that is the dispute that we have to address. But that shouldn't hold up. The building itself isn't on that section. And at the last meeting, the guy said, well, you have 75 parking spaces for a 36 occupant building. You wouldn't even need the extra parking if you didn't, but we're gonna reconfigure the whole lot to make it more habitable.
So I think that the issue is that, though I understand what you're representing, that there were mistakes made with the deed, I'm just hesitant to advise the board to continue with this. Because if the board grants relief for what you've requested, there's a chance that that'll impact other property owners' rights who aren't present, who can't make any kind of statement one way or the other. Bluntly, I would likely advise the board not to consider this evening until this property line situation can be rectified. If it's possible, and if the board would consider it, and if the applicant would consider it, would this be something that could be tabled for next month? And if the other owners are in agreement with you and are willing to come out here and testify to that fact before the board or send representatives to that effect, so that way we know that others are not getting their property rights unduly trampled upon, I think that would be the safer side.
So the attorney is here for the owners, and it only refers to the dimensional requirements for the new parking.
Mm-hmm.
So the variance for the alterations, the replacement, and the rear setbacks doesn't have to do with ownership of another side. So they're just talking about the dimensional parking of the new parking spaces.
Okay.
So
If I could make a recommendation, I think one of the things, if you would describe your variances and what you'd like to do a little more,
so
go through each of the ones.
so the building, I can explain it perfectly.
Give me 1 second.
Okay.
Listen to that. That's the audience. If there's anybody here that she she can state what she wants to state up here, and then we can kind of continue this on and kind of make a determination from there. How's that sound?
Fair.
May I ask a question before we proceed? So I know, so there are 4 variances listed, but we are as a board are only concerned with 3. Is that? Because I only have 3 listed on my agenda.
Right, I split them up when I was talking about it. There's side and rear setback.
Okay.
I think they're included as one, so it's 3 that are listed on the, yeah. Where's that?
Okay.
Look at your variance review.
Oh, I'm sorry, I was looking at the wrong paper. Yeah.
It appears,
Yeah.
it appears to me, and I've studied this all day, that there are 2 of the variances, including what to me would be the primary one, to approve the basic concept of the use and the change. 2 of the variances are not affected by the disagreement about the survey, about the property line. And because the applicant has been working on this project for quite some time, is why it occurred to me this afternoon that, as I put it earlier, if it's too wet to plow, why don't we clean the chicken house? Why don't we deal with what we can, but that it's not up to any question because of the survey question? And with that much, if the 2 variances that are not affected by the survey question, if they are both approved, then the applicant has some additional reason to proceed with additional costs after putting in a good bit of money invested already in the project.
Sure, I agree with Vice Chairman Holman that I think it'd be best to hear from the applicant at this time to walk through the different variances to get a better picture, and then we can move on from there. But your point's well taken, Mr. Williams.
I agree.
So what I'm looking to do is build vertically on the rear building that's already existing. So we're not going forward, back, side, or left. We're just going vertically up on the building. So currently we have restaurant in the front, parking spaces. So the variance 2 for the rear and the side is because the building is 5 feet from the rear, and I think it has to be 10 feet now. So we have to have the rear and the side because where the building sits, you would have to move the building in order to meet that. So that is the main 2. The parking was on the side where the driveway was. It's a curve cut that was put in by, I believe, PennDOT. And our parking, to get to the spaces on our lot, you have to drive in the parking lot and then pull into our spaces. I have owned it since 2018, and we have always used it. We never had an issue. The owners before, they didn't, so it kind of came as a surprise to myself and attorney, Mr. Roof at this time. We do have a survey, and we do have a deed that shows the description of the survey in the deed. And they said that they're going to go back for this additional side. Currently, it's a driveway, so we can't really make parking into a driveway because it's already a driveway. So we can't change the driveway without your permission. But I would still want to move forward in having the plans looked at because the building itself doesn't really need the parking once we tear down the front building. So it takes years to build a building, almost 3 to 4 years, just 2 years in planning. But by the time this building is actually done, then that time we would have the parking situation cleared up and anything else with the city cleared up. But we wanted to keep moving the progress forward.
Two more.
Correct. Vertically. Correct. Correct.
Dude, what's the side variances for? You said in the back it's supposed to be out.
It's
10 feet. It's only-
correct. It's only 5. Correct.
Okay.
And then the side is that the property is built, the rear property is built between 2 different parcels. No. None at all.
I'm always concerned about the pavement, about the building, about the construction. And I know you indicated at the Planning Commission, as I recall, that you had, you have quite a background in property that you own some,
That's correct.
and you didn't just start on this last week.
That's correct.
Are you satisfied that, I mean, some 150-year-old double-walled brick buildings, it's pretty safe to assume they can hold an additional floor or two. Do you have professional studies or
Spent
analyses
$100,000 on it, sir.
or whatever? You see where I'm headed?
Yes, I have. I gave the blueprints to zoning about 2 years ago. I spent already $250,000 on this, and I haven't even started to do anything. And you're right, I do own multiple properties throughout the city, multiple. I got 31 unit motel, 16. I just finished a 10 downtown Screen Art Studios. I have been in the real estate game since I was probably 15, and I had multiple properties in New Jersey, Philadelphia, Harrisburg, and I also have a 25-unit property in Pottsville that I just bought. So I really know the inner workings of building a property up.
I felt I had to ask the question.
No problem. No.
Because, you know, it is not a 200-year-old double-walled brick building that looks like it would withstand a nuclear attack. It's a motel.
Yeah, it doesn't look it, but the actual inner walls are all center blocked. So the outer and the rear walls are all center blocked, so it's like super, super strong. It's a hardened 2-foot wide by 4-foot depth footers that the building is sitting on. So they built the building really, really strong.
So there's more to it than meets the eye. from the
Correct,
outside.
correct. So I had Providence Engineering that was, when they were downtown, come and do all their site work, digging, check the footers, check the foundation, check everything you can think of, wind load, height load, to say that the project is actually safe.
And you were asked at the Planning Commission if you're sure that there's a market for it,
Correct.
for what you want to do. And now there was also some discussion that looked to me like it might be worth my hearing it, but people at the Planning Commission don't seem to think that, I don't know if there are 3 people or 300 people out there watching our meetings on TV. But if you don't turn your microphone on, or if you conduct a conversation 8 or 10 feet away from that microphone, you look like a mime on TV. People can't hear what you're saying. So I just, if anybody from the Planning Commission is hearing this, I'm fed up with wasting time watching half a meeting and half of it that, you know, if what you want to say is worth saying, turn your mic on. Thank you.
Thank you.
Are there any other questions for the applicant, or should we go to public comment?
Actually, I have one question. The driveway or the questionable part, is there any other use for that other than pulling in and out of that area?
So I was told by the owner that she said PennDOT or somebody put that in without her knowledge. And to my knowledge, the previous owner said it was put in because of the traffic load in and out of the restaurant at the time. So it is a driveway, but they said it was parking. We said it's a driveway. It has always been a driveway. The parking spots have been there 60 years, I believe the people own the building. And I do have a survey and a copy of my deed with the description if you would like to see that shows that space.
All right, we'll go to any comments from anyone else who has interest in this case.
Good evening, everyone. My name's Charmaine Nyman. I'm an attorney with the law firm of Barley Snyder. I'm here on behalf of Carol and Marvin Schroll. They're the neighboring property owners of this piece of property that I know there's some confusion about. They do regret that they're unable to be here this evening. So just a little, I think that their objection is the fact that they did, so I'm sorry, let me back up. They became aware of this matter when they received the notice in the mail for the variance request of Mr. Dean. And when they had done so, they obtained a copy of his plans and realized that on, I believe it's page 6 of the plan, where it shows his property line, they were under the impression, since they've owned the property, I want to say around 1990 they purchased this property, that they were the owner of that portion between where the building is shown on the plan and where, and that like 50-foot swatch of land. They did go out and hire a surveyor. Since then, we did not have the results of the survey at the Planning Commission, but we do have the results of the survey this evening, and I have copies if the board would like to see them, which does show that we are the owners of that 50-foot tract. We have been in correspondence with Dean. We have asked for a copy of his survey. He'd indicated that he had one, and we thus far hadn't seen it. But really, my clients are really just concerned with the fact that we recognize he's asking for a variance from the dimensions of the parking, but we don't know exactly where those lines are ending for those parking spots and the access to the parking spots across our client's property. And if they're unable to access those parking spots across our client's property, that there potentially is other parking issues. All of this came to light very recently, and so we're trying to work with the landowner to figure out if there's something to do here. We're trying to sort of nail down what exactly his survey saying, our survey saying, to come to the bottom of the dispute, but at this point, it has not been resolved.
Is there a way you can tell us where, I mean, you said something about on his surveys, are we looking
She
at,
has copies of plans.
I have a copy of our survey, and I can show you.
we have copies, I think, of what you gave us.
Okay, yeah, can I approach?
But the question I have is, I'm trying to figure out where these lines match up what's on
May I
Mr. Dean's.
approach and show you, sir?
I don't know if that's what you said, something about number 6 or something.
So, my apologies, these are not the plans that I had seen before. However, it would be right here, and I don't want to draw on your
Sure,
paper, but
go ahead. So I just want,
this would be,
that's where this line is.
yes, so my clients own this building. His plans, the ones that we had seen, which is indicated here, show that the edge of his property line is here. Our survey shows that the edge of his property line is here.
Okay.
And if you don't mind, can I show everyone
Sure,
else
sure.
so that they can see what I'm referring to? So this is where his plans say the edge of the property line are, and this is where our plans say the edge of the property line are, and this is my client's property, and that's his. Okay? And so for your reference, this is my client's building. This line is where his plans say the edge of the property is. This is where our survey says the edge of the property is, and this is his. So this piece right here is what is in sort of dispute right now.
Sorry.
You're okay. So this is my client's building. This is where his plans say the edge of the property line is. This is where our plans say the edge of the property line is. And this is his property. And so it's this portion right here.
This is what's in dispute.
Yes,
Okay, thank you so much.
my pleasure.
Thanks.
Yep, thank you.
May I ask Mr. Dean a question? With your knowledge of this industry and motels and hotels, and what's the likelihood that all of these spaces are going to be occupied by your building?
The reason why.
Excuse me, would you mind approaching the mic so we have you on the record? Thank you.
The reason why I got into the hotel business, I own several properties throughout the city. And I actually help people move. I'm very active, like doing everything. I work all the time. So one of the tenants, I actually moved from the hotel by Home Depot. The modern is, you can't, it doesn't really look like much, but there's like 30 rooms there. So when the lady moved to me, she told me what the rent was, and the reason why she moved to the hotel, because it's so hard to, the utility expenses are higher if you have your own place. People don't believe this, but it's true. So if you have your own apartment, your own cable, your own, everything is higher for that individual. When you're in the motel, you don't have those expenses. You only have to pay for your living and your eating. So it's much more reasonable and feasible for somebody to actually have a roof over their head than to have an apartment. As we know, an apartment average price is $1,000 for an apartment, plus utilities, plus cable, plus internet. And you have to pay so many utilities that it makes it unaffordable for people to get in. As well as the requirement to rent an apartment, you have to have first month, last month, and security deposit, which is really hard because sometimes you're talking $6,000. So in the industry, most people actually don't fill the apartments until tax time because most people can't afford to save up the money. In the motel industry, like I said, I have 31, 16, 10, they're all full. We actually employed 15 people from the Mission. Many people come in town because the Mission here provides services, and they have jobs, but they just don't make enough for an apartment. So we went to the Mission, we advertised, and they say, hey, we got a lot of people on the work program, and they come and they work, and we gave many people places. So we're like the first place that they go to keep them from being homeless.
Okay. My question was regarding the parking spaces that you have.
So we have 75 parking spaces, and I can show you my survey as well, so you can see the main issue.
Does that include the spaces in question, or?
Correct.
Okay,
So there's
so
10
let's assume,
spaces.
yeah, let's assume those weren't available.
If I didn't have
Down to
those 10
65.
spaces, I would still have enough spaces for my building.
Put you down to 65 and you'd have enough, plenty of space?
Correct.
Okay, yeah. So the main question that really we need to overcome is there even, if there's enough parking on the area that's not in question, can't we move forward with pretty much everything?
The board can certainly approve the other variances and deny the variance regarding the parking. I mean, if the applicant's not going to need it, he's not going to need it. I assume that you just, well, I don't want to assume anything. But I mean, with the issue of the property line dispute, and I have no reason to doubt that your survey says what you told the board that it says, but there's clearly an issue here that needs to be resolved, and it would be, frankly, improper for us to make a ruling, which is likely going to get appealed. And so, if the applicant is agreeable to moving forward without the extra parking, without that variance, and the board would consider the other regarding the setbacks, then I think that's a route you could go.
So a quick question. So the variance isn't really for the parking on their lot, it's for the size of the current parking. So the current parking space is 17 by 8, but the code is 9 by 18. So that's the real reason we put in for the variance. It just so happens that the driveway for those 10 spaces is in the lot that's a problem.
And so is that correct that,
So all of the spaces in the lot are not, they were designed prior to the new standard.
right, I guess what I'm saying is though, that you applied for the dimension for all parking spaces
Correct.
on your lot.
Correct.
And their problem is with the 10 that are in dispute.
Correct.
And so if the board would consider and craft relief for you for all spaces except for those 10 spaces, would that be something that you would consider? And is that something that would be objected to by the public? And she can represent that to us if she does.
Yes, that's fine.
appears to be a new variance. You're changing what's
Well, you're-
board on
You're,
what the variance actually is that he's requesting.
Well, we would just be excluding 10 spaces in the variance essentially, so we would be giving him less than he initially asked for, which I'd imagine we wouldn't need to notify the public about giving him less than he asked for.
no, it'd be just be a modification of what he already asked for. So anyone that was notified of that would already have been aware that this is going to be regarding parking spaces. And all we were doing is just excluding certain number of parking spaces from that relief. And that would be my position. Would you have any comment on that? Would you want to have some input from your client's perspective?
In terms of the parking, something that was raised at the planning commission, and I don't know the answer to this, but it's if he doesn't have those 10 spaces, does he have enough spaces otherwise under the ordinances? In terms of, I mean, certainly we would object to approval of the variance on the portion of lot that's disputed. On the portion of lot that is not in dispute that's on his property, I think that we would not object to that from the dimensional variance standpoint, but under the caveat that it does not include the spaces that are located on the property that's in dispute.
Thank you.
Can we just table variance appeal number 2 and just say it seems to be too controversial with the property lines?
Sure.
And we can look at variance 1 and 3 and 4 and make an approval on that or disapproval based on what
Yeah.
the board wants to do.
I like that. And then Mr. Dean and the Schrolls, the owners of 1231, they can proceed with this question as the better angels of their nature. No, that doesn't apply in law, does it? As the better angels of their nature might lead them to discuss a compromise of some sort. Heaven's sakes, what that would do to the legal business if people were able to do that. Or you can spend more money on lawyering up and fighting it out in court than you would probably make from owning half of that strip that's in question. Okay, but I like the vice chair's suggestion. It's all I was hoping for initially. That we could act, I think, on variances. What was it, 1, 3, and 4?
Sure.
And leave the parking table that part of the case and take it up when they have resolved the question of the conflicting surveys.
So, Monty, would that allow Mr. Dean to make progress on what so he's got no opportunity to make progress if we do it that way, right? Because he needs that parking variance in order to proceed with his plans?
No, not necessarily. It would just reduce the amount of parking that he said he can provide to the city. So that's what the real thing will be. And I don't know, what is it then?
So what it is also is because you do have a dispute on the property line. So he is, for the dimensional, what has not been discussed here, and this is the stance that the city is taking on this, he also has a restaurant and a rooming house above the restaurant. So all of the new construction and the restaurant and the rooming house, they all have to share the parking. So with this being said, as far as the property line, like the city is not in the business of disputing property lines. That's up to the two owners to do that, with a survey and in a civil type case. So it will then shift everything else. You got lot coverage that you have to adhere to, and he will not, unless he lessens the number of hotel rooms that he's planning on doing, he's not going to get any further, because next thing is, like, I know Mr. Dean said zoning plans, but they're not zoning plans. The next thing is land development subdivision. And with all everything not being decided, and that side setback too, the other side setback is also a property line that can be diminished, and he would not need that side setback as well. So, and in case with variances, you show hardship, the city's stance on that is he's not showing hardship because he can diminish that property line. So even with that variance sitting, you're proving the other 3 variances, he's not going to be able to move forward with the land development subdivision until the property dispute gets settled. Property line dispute gets settled.
So is there anything we can do tonight to move progress forward, or is it sort of a moot point?
I mean, I'm confident, because we've been in these meetings a lot. I mean, it's been since I've been the zoning officer, and now since I've been with the planning department. So the dimension of that, and he could, he wouldn't even need the parking variance if he lessens the number of hotel rooms he's going to build up. It doesn't really have anything to do with the construction. Like he said, it's a sturdy building. He's got it, and it's enough with that. And it's a nonconformity there, so the rear setback, he didn't cause that. He doesn't have to show hardship because the existing building was already there when he purchased it.
So at the Planning Commission, one of the things, and I meant, and the city knows this, that the front building is going to be demolished. You can't, if you're doing construction, the rooms that's there, the people can't live while you're building on top of them. So the BCO already said you have to vacate the building, but the city says I still have to have the spaces even though the building is vacated, which it doesn't make sense, but it does per se, because by code, you have to have the spaces even though we're vacating the 12 units in order to build up. So what the Planning Commission said, well, if you're emptying the building and it's going to take you 3 years or so ever to build up, then why are we arguing about parking spaces? And I said, because the city's requirement says that you have to have the spaces. And they said, if you look at the plans currently, we had 75 spaces. But with the restaurant, like she said, and the rooms above the restaurant, adding 36 more spaces wouldn't be enough. But we're not adding the 36 until we eliminate the front building. So it's a piece in that.
So that is partially correct. I mean, it's a 50-50 thing. So initially, when Mr. Dean came to us, we said, just do it all at one time. Demolish front, and it was a financial issue with, doing it all at one time. Because if you did it all at one time, did the land development subdivision, we wouldn't even be having any of these conversations right now. It would be okay. But he stated that he had to do this in 2 phases. So of course, obviously, he has to take the folks that are on the first floor of the motel out of there. Can't build on top of them. That would be way too dangerous. So, but he's not demolishing the restaurant, and he's not demolishing the rooms that are above there, and they will still be occupied. So you can't, I don't exactly know how to word this. So, but the existing motel and the two stories, right? You're building up on top of that. The parking is for that, even though it's not built as of yet, and those 12 people will be in his other place. So it doesn't diminish the use that is for that right now. It doesn't diminish the restaurant use or the rooming house use that's above there. So this is why, with the now dispute upon the property lines for that, and then, like we were talking about, he's actually over on 2 parcels anyways at this point. He has 2 parcels, and to diminish that line, then he would need the setback, but he didn't want to do that. Does that make sense? I mean, just without the neighbor dispute, he's on the 2 parcels. So for the side setback to.
Just to clarify what she's saying, you can't say you're not going to have that parking, but you have the parking. So by their code, you have to have the parking regardless if the 12 units are vacant until the 36. But with the planning, I said, couldn't they put it into the paper saying before you occupy the rear building, you have to vacate the front building?
So I'm not telling the board what to do. All I'm doing is stating the city's piece in this. So, and that's when you come to staff, you get and that's staff reviews also say that as well. So that's all I'm doing. I'm not stating that you have to do this or you have to do that. Okay.
It's kind of like, even if you put no garbage out ever at all, you still have to pay for the service.
Correct.
It's a similar thing.
Similar.
I guess it's pretty common in government.
Correct. So even though you're not going to use the spaces for years, you still have to have the spaces
Have to have-
until the front building is tore down.
And there's no option, listening to planning, I know your goal was to keep the front building occupied to help essentially fund the construction, so.
Not really fund the construction, the taxes are like 42,000
sure.
a year there.
So
So there's not really much profit made at that location.
So you wouldn't really be able to, you couldn't demolish the front building first then to rectify?
No, because then you have your 5 to 6 years of paying taxes with no
Right.
revenue.
So then you would have essentially no income coming in.
Correct.
Pay for the okay, got it.
Still have to pay the trash and sewer and everything else on the property.
The restaurant is still open?
Correct.
How's the food?
I believe it's good.
How long, do I have a little while to try it?
Yes. No, the guy has been, he's been in business for many years, so a solid tenant. Yeah.
I guess I'd ask our solicitor for a recommendation, legally, what legally we should be thinking about. I mean, if you say there's maybe going to be an appeal or something on, if we do make a decision, maybe that's not the right way to go tonight.
Well, there's certainly a dispute when it comes to the Schrolls property, and if you were to make a determination to say that he could have those parking spaces in the way he wants over there with no caveat, I would expect that we'd face some kind of an appeal because we'd be interfering with their property rights. I mean, there's a dispute on the books, and so I don't really see a way around that aspect. Regarding the setbacks, I understand the city's position. But frankly, I don't see, my position would be that, first of all property owners were notified of what is going to be happening here today. And second, the applicant's not required to amend his plans to reduce his parking spaces or change how the parking is positioned. I mean, really, it's up to the board. If the board believes that that's something that can be worked with and is reasonable and no public is here to object, I mean, they have a 30-day window to appeal that decision and how that may result. The other option is you could table it and while they try and resolve these issues, bluntly, that's the board's decision one way or the other, how you want to go about that.
So I mean, as I listen to all this, it sounds to me like this is an issue that could be resolved while progress was being made. But we have some kind of weird technicality that isn't going to come into play that is stopping us from making progress. And it's not even a situation that's it's not even a reality. It's just a technicality. Is there any way to get around this technicality that they need to have a certain amount of parking spaces that they'll never need? Does that make any sense?
Well, the board can make a variance to say that you're going to not need those parking spaces. I mean, you know,
I'd love to make that variance.
but at the same time, you know, it might be wiser in the interest of just over caution to table the one variance regarding the parking while that gets resolved, if the board would consider the other three variances to keep, you know, at least the process moving so he doesn't have to wait on that kind of confirmation. If the board was already inclined to grant the setbacks, I don't see an issue with that. But again, I think the real issue is this parking situation, and I'm just wary to say to grant even with a caveat if it sounds like there could be some conversation between the parties and this be resolved before the next meeting, perhaps. I'm not sure if that's a realistic time frame or not. That's how I present to the board.
Let me just ask, is there any possibility that the parking situation could be resolved in a month? And we table this whole process for a month, and we just.
We're not going to need the parking for about 5 years.
I know, but that's just a month because there's a legal issue here that's.
Within that time, I actually offered to purchase their property, and she said she has to speak with Ms. Sherrill about that. That would make it easy.
I will say, you know, if I can have a copy of your survey this evening, and we had just discussed this the other day, if there's competing surveys, and they're both claiming ownership to the land, and if my client isn't interested in selling the property, and I'm not sure if they are, I mean, that, just being blunt, potentially could take a little bit to sort out.
And that's certainly the point, and that's kind of why my initial inclination was saying to table it, realistically table all of it, though I know that's not what the applicant wants to hear, just in the overabundance of caution to make sure that we have a firm grasp on what's going on here, and beyond that, you know, there's a chance that, like she said, that this will not be resolved in a month, and could proceed into a bunch of issues. And so, yeah, I mean, ultimately, the safe thing to do would be to table it.
To table all of it.
Yeah.
And I think that's where I'm at right now, just to be on the safe side, because several things have arose, and I don't want us as a board to put ourselves in a situation where we're overstepping legally where we don't belong.
Would someone want to make a motion to table if there's no more discussion about that, or is there any more? Do you have another comment?
Can I amend for a variance for the parking? Because it's really an issue of parking. So can I say I wanted a variance to decrease the amount of parking needed?
You couldn't do it at this time. You could work with the staff to amend the application, and then next month, after we properly advertise that, we can have that discussion. And if you can correct this issue without even involving them in some fashion, it sounds like that would be a win.
Yeah.
So I would recommend that.
Parking, the park vehicles from their parcel parking on our parcel, and so I would my client just because of prior parking issues that they had.
Okay, thank you.
I make a motion that we table everything until next month to give everyone more time to have more proper information given to us, that we would feel more comfortable in what we would be reviewing in order to move forward.
A second.
Okay, so a motion to table everything until next month was made by President Cena and seconded by Vice Nick Coleman, calling to the vote. Wait.
Aye.
Adam,
Aye.
Franklin,
Nay.
Nick,
Aye.
Sina, aye.
Thank you both.
Thank you.
Appreciate your time. All right, we ready to call the next one?
Yes, sir.
Next, we're calling case number 6-2025-Z-SE-V. The applicant is Sam Lapp of 398 Red Hill Road, Peckway, PA 17565. The owner of the subject property is Amos Stoltzfus of 621 White House Road, Gap, PA 17527. The subject property is located at 222 South Pine Street, which is located in the UN2 Urban Residential Neighborhood District of the City of York. Applicant today seeks 3 variances and a special exception. First, the applicant seeks a definitional variance from 1304.01-1.02.002A, since the proposed site is not a conversion from an industrial, institutional, or commercial use. A dimensional variance for relief from 1304.01-1.02.002 regarding density requirements permitted in the zoning district. A variance from the special exception condition that property has not been vacant for 2 years. And last, a special exception pursuant to 1304.1.1.02.002 for a multifamily conversion from a different use. The application was reviewed by the planning staff of the City of York, and the planning staff recommends denial of all the variances and the special exception. The case is heard by the City of York Planning Commission on February 10th, 2025, by way of unanimous vote. The Planning Commission recommended approval of all requested variances and the special exception. The record before the board this evening consists of the application itself, a zoning determination letter from Officer McMillian, the deed of the subject property, 2 aerial views of the subject property, plans for the subject property, and photographs of the subject property. Ms. Chairman.
If you could state your name and also give the spelling for our stenographer.
Good evening. My name is Sam Lapp, S-A-M-L-A-P-P.
And just want to take your time and give us your information as far as what you or your client would like to do.
So I purchased this property September of 2024. I believe it was September. I was under the impression it was a 2-unit property. I told title company to check to make sure it's a 2-unit property, and they did come back to me and say it's confirmed as a 2-unit property. So I purchased the property and held it for about a year, and in October, I believe I have these right, in October of 2024, in 2023 I had purchased, in October of 2024 I was on schedule to sell it, and a week before I sold it I was aware that it is not legally a 2-unit property. At that point, the buyer had already had costs into it. I told him that I would try to, after he buys it, I'll try to see what I can do to get it licensed as a 2-unit. If not, I told him I'll buy it back. I had called the city at that time, and they had told me that the county records are wrong, and that I should have called the city because the county records had it showed as a 2-unit, but apparently it wasn't with the city.
Monty, do you know how that happens? How does the county?
Well, with the county, when certain owners have a single family and they're converting it, sometimes they call the county just update it, but the county don't reach out to the city to make sure.
So the county just says, okay, so you made this a 2-unit, good, we're gonna write that down.
Yep, and vice versa, when sometimes they have a 2-unit and they revert it back to a single family, they're not reaching back out, so the county will update their stuff. And that's how we come to find out stuff is not updated, and we give them the actual, what we have in our system, what the unit count is for each property in the city.
That'd be nice if the county communicated with you.
Yeah.
Or it would be nice if we could get the word to the county tax assessment office that when they get an inquiry about a zoning matter, there's no such thing as York County Zoning Department. They don't do it. Why they can't simply tell callers, you need to call the City of York Zoning Department about that, and say nothing more. The solution is so simple,
Yep, I agree.
except that apparently nobody's getting the word to them.
So in this home, you're saying that it is, set up as 2 units?
Yeah,
So there is separate, water, gas, electric?
yes. So when we had purchased, so the reason I was able to even find out about this before, like it was literally a couple days, was there was 2 electric meters at the property, and I was going to put in a third one for the common, and I was told at that point that because they were applying for a permit through the city to get that third meter in for the common area, I was told at that point. So that's how I found that out. But yes, there's 2 kitchens. It's set up. I mean, you'll see with the pictures there. There's technically 2 meters, which, if approved, I still plan on putting that third one in to make it, having the common area and the 2 others.
Two gas meters, I see that picture.
Yeah,
Two water heaters.
that's right.
And it's designed where there's an entranceway that goes into, it splits first floor and then goes up to the second floor. And it's being rented, it's been rented now, according to your paperwork, I think I read somewhere between, their estimate is between 10 and 20 years. It's been like this for a while.
I mean, I don't know how long it's been like this. I'm just, the second floor, I'm assuming that kitchen that was put in was probably, that conversion, and those are pretty old. I would assume at least 20 years is my assumption based off of those cabinets.
And I assume the layout, really nice illustrations, by the way. But, and in many cases, I could figure out what it was, even though they weren't individually labeled. But I assume that apartment 1 is the first floor, and then apartment 2 is the second and smaller third floor.
That's correct.
Yeah.
And then the first floor comes in in the front door in the common area and goes up the stairs. And then the second floor goes up the stairs. The first floor, there's a door that goes to the left, and there's also a rear door for the first floor as well.
And both apartments are currently rented?
Yes. Yes, they were rented when I had purchased them, and they're still rented.
The neighboring houses, are they apartments pretty much too? Or, you know?
I don't know.
Don't know. Okay.
I've
I mean,
seen.
in your pictures, they kind of look like it's 2 mailboxes in the next door. Really can't tell on the orange place. So the neighborhood itself, and I live right down the street myself,
Yeah, in this block, most of the houses are multifamily.
Yeah, so it's
It's a good mix.
pretty much our neighborhood on Pine Street there.
The street picture is your blueberry house between a lemon and an orange.
There you go.
Be easy to give directions to somebody.
Except there's 2 orange buildings.
Common area, what do you mean?
So when you walk in the front door, there's a door that goes to the left, which is the first floor, and then there's a door that goes up to the second floor.
Okay, so you're saying that's the common?
Yeah,
Okay.
it's just a small space.
Any other questions from the board?
No, ma'am.
So the people you sold it to own it right now, you're here just for the benefit of them.
Yes.
You're no longer the owner.
I mean,
If
so
you were to
this
say no,
this caught me off surprise, and I wasn't sure what to do. I thought about canceling the sale. It was just a couple days prior. And I told him, I said, he had already incurred costs, the appraisal, the banks, all this. And I was like, let's move forward. I said, worst case scenario, I'll have to buy it back because I had sold it to him as a 2-unit property. So I told him that, worst case scenario, it'll be, so yeah, I'm just following through with this.
Good job on that.
You do business the old-fashioned way. You ought to run for office. You're needed.
Yeah, if we're good. Yeah, I'll move to approve a variance to the definition of multifamily conversion from a different use as defined in section 1304.01-1.02.002A at 222 South Pine Street in the UN2 zoning district.
Second.
Okay. So it was moved by Adam and seconded by William. And we're calling for the vote. Blade,
Aye.
Adam,
Aye.
William,
Aye.
Nick,
Aye.
and Sina, aye.
And I'll move to approve a dimensional variance for multifamily conversion from a different use found in section 1304.01-1.02.002 to include conversion of a single-family home into 2 units for the property at 222 South Pine Street.
Second.
Okay. It's been moved to be approved by Adam and second by William, and we are calling for the vote. Blade,
Aye.
Adam,
Aye.
William,
Aye.
Nick,
Aye.
Sina, aye. He was hesitant.
And I'll move to approve a variance to waive the special exception provision that the property must have been vacant for 2 years found in section 1311.11C1 for the property located at 222 South Pine Street.
Second.
It has been moved to be approved by Adam and second by William. Calling for the vote. Blade,
Aye.
Adam,
Aye.
William,
Aye.
Nick,
Aye.
and I, Sina.
And I'll move to approve a special exception to allow multifamily use as defined in section 1304.01-1.02.002 at 222 South Pine Street.
Second.
It has been moved to be approved by Adam and second by William. We're calling for the vote. Blade,
Aye.
Adam,
Aye.
William,
Aye.
Nick,
Aye.
and Sina says aye.
Thank you, sir. Appreciate your time.
Good luck.
I appreciate
Thank you.
Thank you.
Are we adjourned?
Oh, yes, we're adjourned.
Sorry.
I apologize.
Yeah, no. Oh, you're new to the gavel. Yeah.
You got a new name.
I noticed. And frankly, I think a little more sociable than she